Hi, and welcome to our final session in our Small Business Month webinar series. I'm excited that you all have been able to join us this month in learning more about how to protect and grow your business from a legal standpoint. This final topic is going to be one that you probably don't want to think about right now, but it's definitely important to consider and to think about so that you can always position yourself as an entrepreneur and your business to be able to try to avoid them as much as possible, as well as to implement strategies and structure in your business to make yourself legally sound and legally defensive, right? So that if anything does occur, you are in the position to be able to have some sort of legal backing that your business can provide to protect its assets. So, the title of today's webinar is Defend and Preserve. We'll be discussing business disputes, real estate protection, and legacy planning for Texas entrepreneurs. Alrighty, so breakdown of today's agenda. When business goes wrong and knowing your legal options, business disputes and litigations, how to fight and win, real estate investment structure and asset protection, business succession planning, which is essentially estate planning for businesses, estate planning for business owners, which would be the individual separate from the business, annual legal audits so that you know how to protect what you've built, and then we'll go ahead and answer any questions that anyone may have. All right, so the first topic, business disputes and litigation. When something goes wrong, how can you speedily correct it with strategy? So here's some common business disputes and your options of how to deal with those types of disputes. Breach of contract. This is when a client won't pay, the vendor didn't deliver, or a partner violated the agreement. These are the most common disputes that we handle, and we typically handle them with two options. Our pre litigation team is really good about sending demand letters to try to negotiate some sort of resolve or settlement on your behalf if a breach of contract does occur. And so, what that would look like essentially, if there's a client who won't pay, we can send a demand letter on your behalf with law firm logo, demanding that they pay by this specific date or further legal action will take place. Sometimes it requires us setting up a payment plan on their behalf and making sure they're paying you on each specific date of each month or biweekly, whatever is agreed upon. Or maybe we're trying to negotiate and settle somewhere in between if both parties have breached or if there's a mutual breach of that contract. So it can look different. Now, on our litigation side, we also have a litigation team that can file lawsuits and answer lawsuits for breach of contract matters. As I stated, these are very, very common disputes that we handle. We typically suggest that you try to resolve the matter pre-litigation, so before any sort of lawsuit is filed, and see where you get, because litigation is just so lengthy and so expensive. And a lot of times, even if you do file a lawsuit in a case, most cases settle before we actually get to trial. So just keep that in mind. I know that some people, when they're in some sort of dispute, they're like, no, I want to sue. I want to sue. But as the legal bills start to add up, the mental toll starts to weigh down on you. And the time from the initial date of filing that lawsuit all the way until we go through different motions, hearings, depositions, all the way up into trial can just really weigh a lot on you as an individual. So we really do try our best to handle those breach of contract matters to the best of our ability pre-lit. And that's, before a lawsuit is filed. Partnership disputes. So these are disagreements over management, profit sharing, or direction can paralyze a business without the right legal intervention. And so sometimes people form businesses with a business partner, with a family member, with an investor, but nothing is put in actual black and white writing and signed. Sometimes they actually did have an agreement, but then the parties never signed it, or one party signed it and the other party didn't. And so we're left with this issue of trying to figure out what type of resolve you legally have when there is not an agreement in place that's signed by both parties. And so we can handle that once again, pre-litigation or on the litigation side. So any sort of disagreement over management, sometimes it can be resolved by simply putting an operating agreement, a joint venture agreement, or bylaws in place that can properly outline the management structure. And so moving forward, there's no sort of misunderstanding or disagreement about that. Or sometimes it can actually result in a partner leaving the business and there needing to be some sort of buyout or dissolution of that business. So the result of partnership disputes can vary depending on how much both parties are actually willing to work through the matter. The issue at hand that is causing the conflict can also play a role in how it can be resolved as well. Collections and debt recovery. A demand letter from an attorney often recovers unpaid invoices where repeated emails have failed. So, once again, we did talk about demand letters being common, but they're not just common for collections and debt recovery. They're pretty much common for any sort of main dispute that you may run into with your business. We would typically start with sending the demand letter and trying to have some conversations with the other side or opposing counsel about if any sort of settlement is likely to resolve this type of matter, or if both parties are just in such huge conflict and mismeeting of the minds that maybe any sort of pre-litigation resolution just isn't going to cut it in this specific case. Business litigation. This occurs when negotiation fails. We litigate aggressively in Texas courts, protecting your business interests from start to finish. Unfair competition claims. This is a tortious interference with your business or with the day-to-day activities of your business, preventing you from being able to make money. Misappropriation of trade secrets and trademark infringement all require immediate legal action. And then we have mediation and arbitration. And these are two types of alternative dispute resolutions. And many business contracts actually have a portion of the agreement that is titled alternative dispute resolution or dispute resolution or alternative resolution, something of that nature, that either states that mediation is required before a lawsuit is filed or that arbitration is required to resolve or settle any sort of conflict, which would prevent you from being able to file a lawsuit. You would have to do arbitration. Arbitration is a form of alternative dispute resolution where both parties have to pay a certain amount to arbitration. Arbitration tends to be pricey, so just keep that in mind. However, you don't go before a judge, right? There's no possibility of a jury. You don't go before the judge, you go before an arbitrator. And the arbitrator is not always someone who has served as a judge. It's just someone who is trained to be an arbitrator. They listen to both sides of the conflict, of the disagreement, and they make a final decision. And that decision is legally binding. So you can't try to appeal it like you could a lawsuit. And so that is something that's important to consider when you are entering into a contract with a business partner, with a vendor, with a client. In that section that's titled Alternative Dispute Resolution, is arbitration something that you're interested in, or is it not something that you want to consider? Maybe you want the option to be able to file a lawsuit and go to court, have your case heard before a jury who may be more understanding, or just have your case heard by a judge with the option to appeal if you feel like it wasn't fair. Arbitration does not give you that option. However, it is quicker than trial. In the end, you probably won't pay as much in legal fees for arbitration because it's speedier, right? You don't have all these motions that need to be drafted, all these hearings that the attorney has to attend, depositions or things like that leading up to trial. And so while the arbitrator's fee may be high that each party has to pay in order for the arbitrator to be present for that arbitration hearing, it could be less costly overall than litigation, or on the other hand, quicker, right? So you can get some sort of quicker resolve and you don't have this matter lingering over your head for a while. Mediation, on the other hand, is also a form of alternative dispute resolution where both parties go before a third neutral party to have the matter heard. Mediation can occur after a lawsuit is filed, and then you can enter the mediation agreement in the court's records so that if any sort of stipulation or part of the mediation agreement is not followed, then the parties would have the opportunity to go ahead to file suit. Or, if that mediation agreement outlined what breach of that agreement would result in, then that would go in place. But mediation agreements can take effect after litigation has enacted. So after a lawsuit is filed, and it can be filed into the court records and is legally binding. So we represent clients through every phase of alternative dispute resolution, as well as in litigation, as well as in pre-litigation with demand letters and negotiation conversations for settlement. If your business is sued, act immediately. People make the mistake of just sitting and thinking that a matter will go away. And when it comes to legal matters and an attorney is involved, it's not going to just automatically go away. And so if your business is sued, you need to act immediately. There are deadlines that need to be filed. So if you get served with an actual lawsuit, you can't just say, okay, well, I'm busy this month, I'll handle it next month. No, there are deadlines that we're getting ready to discuss, and in which you need to answer the court and have something on file. So in Texas, you typically have 20 days after service to file an answer. So that means once someone serves you with a lawsuit and they say you've been served, they hand you these court documents, you have 20 days to be able to file an answer, right? Which is you answering that lawsuit and stating that you either agree or you deny these allegations and file it with the court. Missing this deadline results in a default judgment. So this is why it's so important that you act immediately, because if you miss this deadline, a default judgment could be filed against you. And that means that the plaintiff wins automatically. So whoever is suing you would win automatically if you fail to answer the lawsuit within the 20-day deadline. So however much they've claimed in damages in their petition of the lawsuit is what the default judgment is that's filed against you. So if they ask for $50,000 and you get a default judgment, you owe $50,000 and you have that judgment on your record just because you never answered. You just thought it was going to go away, or you didn't want to deal with it, something like that. You didn't take it seriously. If you are served with a lawsuit, you need to answer within 20 days in the state of Texas. So day one, once you are served, do not respond to the plaintiff directly. Preserve all documents, emails, and communications related to the dispute, and call an attorney, right? Find an attorney. See if this is something that you can afford to be able to represent you in this matter. If this is something that does require an attorney, and then if you're unsure if the documents that you have been provided or that you're viewing are an actual lawsuit, you could at least try to book a consultation with an attorney where they could tell you if the documents are real or if a lawsuit has actually been filed against you. Case evaluation. This should happen within the first 5 days. Your attorney will review the complaint, also known as the petition. It will identify claims. It will assess your defenses and advise on litigation versus settlement strategy. So like I said, even after a lawsuit is filed, there is still a possibility to settle the dispute. And so that attorney can kind of talk with you about strategy, about when we may want to start discussing settlement. Maybe we want to get to a certain point in that litigation phase before we start to reach out about settlement, or we want to try to uncover some evidence or show the court and other party what evidence we have. And once we're able to show it, then we can try to talk about some sort of settlement. So that's also what can happen. Days 5 through 18, you want to start drafting the answer. So the answer is a formal response that is filed denying the claims, asserting affirmative defenses that you believe you have, and making any sort of counterclaims. A counterclaim is when someone has sued you, but you feel that you also have legal grounds to sue them for something. You can put in your answer what's called a counterclaim, and which means you're countersuing them. So they're suing you for breach of contract, you're suing them for defamation or something of that nature. That can be a counterclaim that you can put in that answer. Day 20, file the answer. Your answer must be filed with the courts before the deadline. Missing this date means automatic default judgment against your business, which you do not want to do. Discovery phase. Discovery is the exchange of documents. It also is when they are taking depositions. So that is an interview with each party who plays a major role in the case, any specific witnesses that the case may require. And it really can make a case. So, strong documentation is your biggest asset when it comes to a lawsuit and your business being sued. And then the resolution part, you either go to trial or you settle. And once again, I can't stress this enough because people think that once the lawsuit is filed, that means that you're going to trial. And that is simply not the truth. Litigation is just one form of strategy to try to get some resolve in a matter. So you either will go all the way to trial after you've been sued, or you could even settle after you've been sued or you sue someone. So don't automatically assume that just because a lawsuit goes into place that you're actually going to see the light and day of trial, because that's just not true. We've had cases that have literally been settled the day before trial, cases that have been settled halfway through trial. Maybe trial was set to last 2 days or a week, and halfway in between that time, the parties agree to settle, right? Depending on how the case is starting to turn out in court and what makes sense for the parties. Real estate investment structure and asset protection. One lawsuit should not threaten your entire portfolio. So, how Texas real estate investors should structure their portfolio of real estate properties. Holding all investment properties in one entity or in your personal name means a single lawsuit can reach every asset you own. And to break it down, what this means is that if you own all of your investment properties in one LLC, or you own all of your investment properties under your personal name, if that LLC, that one LLC is to be sued, and let's say a default judgment is placed against the one LLC, they could attack each of the properties that that LLC owns. Even if the issue only occurred with LLC with property number one, and that LLC owns 5 properties, they could try to attack all 5 properties and have them taken from you, just because you've combined all of your liability by having one LLC own 5 different properties. Once again, the same is possible with owning all of the properties under your personal name. If you're personally sued, even for something that has nothing to do with the properties, maybe you fall into some sort of medical debt or credit card debt, and a judgment is placed against you in a court of law, and they go to try to attack your assets to cure that judgment that has been placed against you. They're going to look at everything you own, right? The court may ask for an inventory of all the assets or property that you own as an individual or as a business, and they will break down to see where they can try to capture any sort of valuable assets to pay off this judgment or this debt that is owed in the dispute. So, one way to look at this is having a holding company that owns each of the property. And then you'll have an operating LLC for each of the properties. And that can separate your liability. Whereas the holding company has ownership of each property, and it can lease the right to use those properties to the operating LLC. And then from there, the operating LLC would pretty much work almost as like a property management company, where they'll operate the day-to-day business for the property. They'll take payments for rental payments made on the property. They will pay for any damages to the property that needs to be resolved, but they don't actually own the property. The operating LLC does not own it. But they'll also enter into contracts to lease out the property. So that is one strategy and one method to be able to separate the liability of the different properties while still having good legal protection in place. And once again, that's having the holding company own all of the properties and then creating separate operating LLCs for each property that will manage the day-to-day operation of the business, accept payment, enter into contracts, own intellectual property if needed, and so forth. So each property in its own LLC means that liability from one property cannot reach the others. This can result in isolated liability. So if something happens with property two, and that LLC number two, it does not affect the properties in 1, 3, 4, or 5. This can result in clean ownership records, whereas separate LLCs create clear title chains and simplify property sales and refinances. Estate planning integration. Individual LLCs can be placed into trust or transferred to heirs with minimal disruption. So it can be helpful in that aspect as well. Real estate contracts. Never sign them without review. I can't tell you the amount of times that people are coming to us because they need to get out of an agreement. They don't understand the agreement that they rush to sign. They want to try to make some changements in an agreement, but they don't know what rights they even currently have under the agreement. And so it's so important to have an attorney, a real estate attorney, review your contract before you actually sign it. Don't be in such a rush to sign. It is very common to be able to request that you have time to have an attorney look over your contract. You don't want to take months to have an attorney look over your contract, but being able to say, you know what, can I have a week or two to have my attorney review this and get back to you with any specific changes we may want to request or any specific questions I have about my obligations or my rights under the agreement. So purchase contracts, they look for as is clauses, earnest money forfeitures, due diligence contingencies, and seller representation requirements all need attorney review. So those would be the main areas we'll be looking for to kind of let you know in this specific agreement, what does it say about each of these topics? So what does it say about earnest money forfeiture? If you decided to pull out of the purchase agreement, what happens to your earnest money? Do you still have an option to try to get it back, or did you lose that option if you pulled out of the purchase contract in a specific time frame, or just in general? Maybe it didn't discuss the time frame at all. Due diligence contingencies and seller representation requirements. And so just make sure that you're having an attorney review this. These are going to be areas where the attorney is going to look for in deeper investigation, right, to see what exactly it says in your contract and make sure you have a good understanding of what your obligations and rights are. Lease agreement. So whether it is a residential lease or a commercial lease, they have dramatically different protections. Investment property leases need custom clauses for Texas investors. So for some of our clients, you know, who do have commercial leases, depending on your specific industry of your business, certain clauses may be added in, right? That may not even matter to other industries. And so if you have a medical clinic versus if you're going to run like a trucking business or something where you actually just store items that are going to be then shipped across state lines or something like that, what you would require out of that commercial property may be different. Maybe you need significant amounts of water sources because you are going to run a hair salon or a barber shop out of the property, or you may not even need any sort of water sources if you're just going to use some sort of commercial warehouse to store property that you sell online. So having certain custom clauses is important, and making sure that the needs of your business are met through that lease agreement is very important as well. Title and survey review. So this is when you go over eases, encumbrances, and survey issues that could affect property value and usage rights. You want to identify them before closing, because any sort of contract clauses that say that the seller is not responsible for any of that, that puts the onus on the purchaser to do the review for any easements, encumbrances, and survey issues. And not disclosing certain things. You want to make sure that the contract doesn't state that, you know, the seller has no duty to disclose any of these items or anything like that, because that could definitely affect your ability to enjoy the property and your rights to be able to use the property in the way that you need to or the way that you would like to. Deed drafting and transfer. So improper deed language can create title defects that complicate refinancing, selling, or passing property to heirs. So you really want to make sure that these documents are properly reviewed by a lawyer or an attorney, and make sure that they are filed properly as well with the county in which the properties are located. Landlord-tenant disputes. These include evictions, security deposit disputes, and lease violations in Texas, and they follow strict statutory procedures. One misstep restarts the entire process. And so sometimes it's valuable to have an attorney on hand that can file the evictions because state of Texas requires specific steps to be taken in order for the eviction to be upheld, and you need to make sure that each process is filed or followed correctly. I'm sorry. They want to make sure that they're not actually throwing someone out of a residential property when all of the steps at hand that are outlined in the statute weren't actually filed. 1031 exchange guidelines. These are tax deferred, like kind exchanges that have strict timelines and identification rules. They require for you to coordinate with legal and tax advisors from day one. And so I want to highlight that certain items or certain contracts you sign have tax implements as well as legal implications. And sometimes your attorney and your tax professional, your CPA, whatever you work with, may need to talk with each other to make sure that the contract or your agreement that you're entering into can protect you on both sides, tax side and legal side. So it's not uncommon for us to meet with someone's accountant, meet with someone's tax professional or financial advisor to be able to discuss what our roles are, right, as professionals, and figure out how we can best protect you as the client. Business succession and estate planning. So protecting what you've built for the people and causes you care about. I feel like this is one of those areas where people hear the term succession planning and don't really know what it entails. However, once they find out what it actually includes, they're like, oh, yes, like I actually need this in place. And I've actually been wondering about this because what I'm building is so great and phenomenal. And I want to be able to allow my heirs and my future generations to benefit from this. I want to have a plan in place to be able to protect what I'm building so it can continue to grow in my legacy and without me needing to be so hands-on or without me being alive anymore. And so that is where business succession planning comes into place. So business succession planning, the 5 key questions. Who is going to run your business if you can't? And that doesn't also mean that you have passed away. That could just mean maybe you're in a 1-month coma, right? But you still have a business and people rely on that business for their income. People rely on that business for a specific service or product. And the continuation of the business and day-to-day operations needs to occur. So who runs the business if you can't? In order to solve this, you need to create a business succession plan. The business succession plan will then identify a successor. This is a family member, a key employee, or a co-owner, and document their authority in your operating agreement and succession plan. An operating agreement is in place when you have an LLC, limited liability company. It outlines mainly the management structure of your business. It also will outline the types of liability protection offered to business owners, and it can outline who runs the business if the main owner cannot. So, number 2, who owns the business after you're gone? So, after you die or pass away. Without a plan, business interests pass through probate, which is a lengthy court process that in Harris County, Texas, where Houston is located, sometimes can take 1 to 2 years to get through completely. And so a properly structured buy-sell agreement or trust can avoid this delay entirely. And when we say trust, this is, most of the time separate from the trust that you have to manage your personal assets. You want to create a business trust that just manages the planning and future for your business. And that way you can outline who owns the business after you're gone there. And you can outline different successors as well. So maybe you have a backup to that backup, and then a backup to the backup to the backup, right? So we just want to make sure that those are in place. Number 3, how is your business valued at buyout, right? So you want to establish a valuation method. What's the book value of the business? And there is a specific term that is used for the process and for the I guess it's like a mathematical calculation that they use, and it's called EBITDA. So how do they multiply that? How do they add up those numbers to be able to get the value of the business? There is a specific procedure, and that's what that refers to. Or an agreed formula by both parties could also be used. So, in a recent case, they were dissolving the business. They did not go through that process of determining the book value. They kind of just went and decided what they needed to pay off and how they were going to split what was left over. But you can outline which method should take place in your buy sell agreement and before a triggering event occurs. Number 4, how is the buyout funded? A key person in life insurance is the most common funding mechanism for buy-sell agreements, ensuring the surviving owner can actually afford the buyout. And so sometimes that is a reality where there are two business partners and they're wanting to separate, but the one who wants to leave the business is asking for a certain buyout rate, and the business just doesn't have that amount in assets at the time, although it has the potential to be able to afford that buyout in the future. It just doesn't have it at that time. And so having something in place like life insurance can make sure that you can actually afford the buyout if you need to. All right. And what happens to employees and clients? So, a succession plan must address client communication, employee retention, and operational continuity to preserve business value during transition. And this is why I say it's important for you to know that a business succession plan is completely separate from your estate plan for your personal matters, because it's going to go into full detail about all the aspects of your business that your main trust or will or your estate plan for your personal assets is not going to touch. Estate planning essentials for Texas business owners. So this is going to be your personal trust or your will, your estate plan that's in place. We like to make sure that the estate plan that you have in place for yourself can touch on the most important assets and most important aspects of your life that you want to be able to make sure your heirs can properly benefit from. Maybe you have a successful business, but you don't believe that your 9-year old, right, can run the day to day operations of that business, but you still want the child to be able to benefit from the rewards and reap the benefits of what that business is bringing in. That's also an option. You can name a successor to run that business while still listing your child as a beneficiary to benefit from that business. And a personal estate plan will also be addressing these things as well. So, last, will and testament. Every business owner needs a will that specifically addresses how their business interests are handled, not just their personal assets. So, your interests, right, are referring to your ownership in that business. Maybe you are a 50% owner or a 75% owner, something like that. It needs to outline how it should be handled. Should it be an automatic buyout where you require the business to pay your heirs the amount in money that's equal to your share of ownership in the business? Or maybe you have a child who is an adult, who, or a beneficiary who's an adult who you believe would actually be a great to step in to take over your place in the business. It can also give the duty to sell off their asset and then give the proceeds from that sale of their ownership interest to their heirs or to their beneficiaries. And so that's also an option as well. There are many options to consider there. Revocable living trust. Placing business interests in trust avoids probate, maintains privacy, and allows for seamless management during incapacity. And so that is also an option. When you do create a trust, you have the option to create an irrevocable trust or a revocable living trust. Irrevocable trusts are common sometimes when you are trying to separate liability, trying to make sure that you're putting certain assets in the ownership of a trust, but still want to have some sort of management or control over the trust. With an irrevocable trust, you can be the grantor, so the person who actually owns the assets now and is placing them in the title of the trust, as well as a beneficiary of the trust, so someone who can still benefit from those assets. And then you can name successors or people to be able to reap those benefits of the beneficiaries. So, kind of like backup beneficiaries upon your passing. A revocable living trust means that you are only the grantor. You cannot be a beneficiary. You relinquish all ownership of those assets and place them completely into the name of the trust. And this is how you really avoid any sort of judgments being placed against you from being able to attack anything that you owned personally. You put those items in the name of the revocable trust and it can't be touched because you no longer own those. The trust own those. Revocable living trust is also how you avoid probate. An irrevocable trust, because the grantor could also be the beneficiary, means that some of those assets could still have to go through probate or be attacked by creditors. And so, a revocable trust, although you're relinquishing power completely, it does have the benefit of not allowing judgments or creditors from being able to touch those assets. Buy sell agreement. This coordinates with your estate plan to ensure the business can continue without disruption when ownership must transfer. Power of attorney. A power of attorney is discussed in two main ways. A durable power of attorney designates who manages your business and finances if you become incapacitated before a court steps in. And don't think that this has to be one person. You could name two individuals to split that power or that obligation equally or in whatever percentage you would want. And then we also use the term power of attorney when talking about a medical power of attorney, and that person is in charge of making medical decisions on your behalf when you cannot. That's either that's when you're still alive, but you're not in the right mental capacity to be able to make those decisions on your own. Your medical power of attorney can step in and make the decisions on your behalf. It is important to note that a power of attorney is no longer valid once you pass away. Business interest in trust. So transferring LLC membership interest to a trust avoids probate and can provide significant estate tax planning advantages. So in the case of someone who, has the minor children, they still want the children to be able to benefit from what the business is making financially without putting the child responsible for running the day-to-day activities of the business. Then you could transfer your interest in the business without having to transfer the right to vote or the right to run day-to-day operations of the business. You can break it down however you want. Charitable planning. Business owners with appreciated assets can use charitable remainder trusts and donor advised funds to give back while reducing taxes. And number 4, how to deal with annual legal audits and protect what you've built. So we want to talk about preventative legal care, which costs a fraction of the emergency legal treatment, meaning that if you can put certain strategies in place now, you can avoid, right, how much it would cost in an emergency situation to treat the matter because you already have certain strategies implemented in your business so that if this does occur, then, there isn't sort of like panic and frantic running around in this. So your annual business legal audit checklist, corporate governance. This is making sure that you have annual minutes in place, officer elections are documented and on file, and your Secretary of State SOS filings are current and up to date. Your business is not in any sort of inactive or tax forfeiture status. Operating agreements should reflect current ownership and management of the business. So you need to update those anytime there is a change in ownership or a change in management of the business. Contract reviewing. All active contracts that are current, signed, and enforceable need to be reviewed continually. Vendor and client agreements have been reviewed in the past 12 months. That's important to make sure of. I like to tell our clients that whenever you run into any sort of issue with a client, with a vendor, and it has become a headache for you, and you're like, I do not want to experience this again, it's time to update the contracts that you're using to see what additional language we can add in there so that you could avoid those issues in the future with any other vendors or any other clients. And we can also amend any sort of contracts that you do have in place to make sure that we can try to avoid those issues from occurring down the line with continuing business relationships. Employment compliance. So employee satisfaction is correct. And employee classifications are correct. You want to make sure that your offer letters, non disclosure agreements, and handbooks are up to date with current Texas and federal law, and that they currently reflect what it is that you want in your business, right? And so, once again, if you experience anything with an employee leaving the business, coming into the business, any sort of issues, you want to make sure that you update your employment compliance documents to make sure that you can try to avoid those in the future. My favorite topic, trademark and IP status. So, federal trademarks are registered and renewal deadlines are calendared. There is no authorized use that has gone unaddressed, is something you want to make sure of. Federal trademarks are such an important asset, I think, that are undervalued. People may hear about a trademark and they're like, okay, I need to put it in place, but don't understand that it's actually an asset for your business that you can own, you can sell, and you can lease. And so it's really important that once you do have a registered trademark, you keep up with the renewal deadlines. They are calendared with the United States Patent and Trademark Office. That is the federal office that issues trademark registrations and that manages trademark renewals. But you need to make sure that you keep up with those deadlines. They'll send you a letter in the mail and they'll also send you email reminders a few times before that deadline to make sure that you can renew your protection. So when you do your legal audit, you need to make sure that one, you have trademarks for any sort of important intellectual property your business uses, business name, business logo, business slogan, product names, or service names. Those are all super important. Real estate and leases, something that our firm specializes in, or shouldn't say specializes, that we deal with a lot, right? It probably has become the bread and butter of our pre-litigation team would be real estate and leases. So investment properties are properly structured in LLCs. Commercial leases have been reviewed before any renewal. We work a lot with structuring businesses and a lot with reviewing contracts, redlining contracts, drafting contracts for real estate purposes. Succession and estate plan. So make sure your buy-sell agreement is current. Have an estate plan for your person that reflects current ownership, beneficiaries, and business structure. And then have business succession plan in place as well to outline the management structure of your business and what the plan is for when you can no longer run the day-to-day of your business. And so, ways that the Curry Law Firm can help with your defense as your legacy team. So, from the first dispute to your final exit, we protect what you've built at every stage. The owner of our law firm, she likes to say that we are a full service business and real estate law firm because we help businesses from the beginning all the way into the end. So, that's from structuring your LLC. Getting you any sort of trademark protection or copyright protection that you need, drafting contracts to use throughout your business, dealing with business disputes and business litigation, and then helping you to dissolve any sort of businesses. We help with it all from beginning to end. So business litigation and dispute resolution is something we help with. We help with breach of contract matters, partner disputes, collections, and unfair competition claims in and out of the courtroom. I talked earlier about our pre-litigation team and our litigation team. We have both. I'm an attorney on the pre-litigation team, meaning that I handle matters that are mainly transactional, that deal with paperwork, that deal with filings and things like that. And then I also help to negotiate settlements and send demand letters for matters that have not had a lawsuit filed against them, right? We're trying to get to some sort of result or some sort of resolve or settlement before it gets to the point of needing to have a lawsuit filed. And then we also have our litigation team that files lawsuits as well as answers and defends you in lawsuits that are filed against you. So we help with both sides in and out of the courtroom. Real estate investment structuring. So this deals with LLC formation for investment portfolios, deed drafting, and contract review for every transaction that you have. We help with that 100%. Buy-sell agreement drafting. This is customized buyout frameworks with valuation methods and funding structures that actually work. So when we talk about valuation methods, that is the calculation or the method used when you're trying to determine in the matter of buying out a specific person or selling someone's assets, what method needs to be followed. I'm sorry. Business succession planning. These are legally binding succession plans that keep your business running and your legacy intact. Once again, when it comes to the actual business, the business itself has what's called a succession plan, and that outlines the future of the business. It's essentially the business's estate plan, right? So, how it should run after you pass away. Now, your estate plan is what you're actually going to put in place for the person, right? For an individual, for a family. So, for the actual business owner, this deals with wills, it deals with trusts, power of attorneys, and business interest transfers that are integrated into one comprehensive plan. An estate plan includes all of these documents. It's not just either or, one or the other. It typically includes a trust, it includes a pour over will, durable power of attorney, medical directives, and HIPAA authorization. And that is your full makeup of the estate plan. And their estate plan could also include you making plans for your funeral, right? It could also include you deciding plans for a specific property that you own personally or something like that. So it goes into detail about your assets as an individual person, while a succession plan is focused on the assets and the future of the business. Annual legal audits. This is something that's super important and that we can also offer to our clients, where annually, maybe it's in July, maybe it's in December, we're doing a legal audit of the business. We're going through the contracts that you have in place, any trademark that you need, or any trademark applications that are pending. We go through the contracts that you have in place. We go through your business filings to make sure they're up to date and inactive status. And we also will go through any sort of issues or disputes that you're having before they become lawsuits or penalties. And the whole goal of the legal audit is to catch problems before they become lawsuits. Proactive compliance reviews can assist with this because we're being proactive instead of reactive. And at this time, I'll open the floor up for any specific questions that you may have. And I'll answer these briefly as we kind of wait, give people a chance to type their questions in. So, my business partner and I are having a disagreement. What are my options? That's a great question. We should look at your operating agreement to see what the operating agreement says about any sort of disagreements or disputes and how they should be handled, right? If your operating agreement has never been signed, if you don't have an operating agreement in place, I think this is a great time to reach out to legal counsel on behalf of the business to have an operating agreement drafted that can represent the ideas of both parties. And an attorney can serve as the neutral third party to kind of put what will be in place that's best for the business. So if the business hired an attorney to create an operating agreement, that attorney is working for the business and is working to create an operating agreement in the best interest of the business, versus if each individual business partner hired an attorney to come together to file an operating agreement, they're trying to advocate for their clients' interest within that business and to make sure that the operating agreement reflects what's best for their specific client's interests. So those are your options. Number one, look to the operating agreement that's already in place. Number two, if the operating agreement is not in place, the business can hire an attorney to draft an operating agreement for the business that can reflect best interests of the business. Or three, each business partner can hire separate attorneys to try to work together to create an operating agreement that can work for their interests. All right, how should I structure my real estate investment portfolio in Texas? So there are two or three main ways. Number one is that you can just have a separate LLC for each individual property that you own and place the ownership of each property in each of those separate LLCs. Number two is you can create a holding company that will own each of the real estate properties. And then you create operating LLCs for each real estate property to manage and operate the day-to-day needs of each property. And then number three is that you can look into the series LLC method, which is unique to Texas. Not all states offer it. I think only about 15 states do. Texas is one of them, where you can create a main series LLC, kind of like a holding company, and then a sub series for each property address that you have for your real estate investment portfolio. What does a business succession plan actually look like in practice? It is planning for the future of your business and planning for when you can no longer make important decisions for the day to day operation of the business. Maybe you're still alive, but you're on cancer treatment, so you cannot be there to make important decisions. You can't be there to sign the checks. You can't be there to make the payments, to keep the lights on, or offer the services that are needed to be able to afford to write the checks and pay the bills, things like that. What is the plan in that place? Depending on the industry that you're in, it may require you to already have a backup with a specific professional license that you hold. Or it can just be something that you're having in place that isn't necessarily required in your profession or in your industry or by your professional license, but you just want to have in place so that everything that you've built for your business doesn't go downhill. And so our founding attorney talks about this a lot, is that, a lot of times once that main person who is the breadwinner for the business does all of the main operating for the business, once they step away, the business crumbles. And so when we talk about what does a business succession plan do, it helps to hold up the structure of the business so that if that individual steps away or cannot make those decisions on a day-to-day basis, the business doesn't crumble. Everything they've built doesn't just fall. So do I need a separate estate plan if I already have a buy-sell agreement? Once again, an estate plan is the planning for your individual assets that covers more than just your business interests. It can cover your vehicle, it can cover your personal home, it can cover your life insurance policies, disability policies, all of that, versus a buy sell agreement is just used to outline what should happen with your specific interest in a business should you pass away or should you need to step away from the business or walk away from the business. So those would be the differences between the two. Yes, you still need a separate estate plan if you already have a buy sell agreement, because the buy sell agreement is unique to your business, whereas the estate plan covers multiple aspects of your personal assets and your personal life. And like I said, it's not just the trust in your assets, it's also the power of attorneys for financial and for medical, your medical directives, and so forth. And finally, what does a legal audit from the Curry Law Firm involve? It involves us sitting down with the client probably for about an hour and a half to 2 hours to go through the contracts that they're currently using in place, both for operating the business as well as with employees. We go through any sort of disputes that they're currently open to make sure that we can try to avoid litigation, or that if it is in litigation, there is adequate procedures in place to be able to confidently defend them. We go through any sort of intellectual property protection via trademark or copyright. We also make sure that your LLC or corporation or nonprofit filings are up to date with the state. And if it's a nonprofit, that your annual filings are up to date with the IRS to uphold your taxes and status. Well, if no one has any further questions, thank you all for joining. Just remember that you've built something worth fighting for. So let's fight for it. We don't want it to crumble. We don't want all of your hard work to go to waste just because you can't continue to be the main individual putting in the work. And so a business succession plan can really help with that, as well as making sure that you have strategies such as contracts and litigation support to be able to protect you in those instances. So the Curry Law Firm is Texas's full-service legal team for business owners and real estate investors, from your first LLC to your final exit strategy. You can schedule a consultation with us by visiting www.theclfirm.com or calling us at 713-574-2070. Thank you all so much for joining. We have thoroughly enjoyed putting on this 4-webinar series for this month to celebrate National Small Business Month. And we hope that you found this information valuable. If you have further questions or want to know how we can protect you on any of the topics discussed, please don't hesitate to reach out. We love answering any questions that you have and figuring out how we can be an asset to you as a business owner or to you as a small business. Thank you so much and have a great day.